Hello, my name is attorney Masa Sam Foray, founder of the Foray firm with offices in Chicago and in Houston. And I am back again today to answer all of your Illinois family law questions. So today's question is it hard for a father to get custody in Illinois? Well, first of all, let me start, and this is probably repetitive if you've listened to many of my other videos, but let me start by saying that we no longer use the term custody in Illinois. There was a change in the statute a couple of years ago when we actually went from the word custody, which was literally stricken and removed from the statutes, to the term allocation of parental responsibilities. There are nuances and differences, but allocation of parental responsibilities is a tongue twister and a mouthful. And so just know that when I'm talking about custody, I actually mean the APR, or the allocation of parental responsibilities. And you can scroll through my videos if you want to look at what the differences are and a little bit more of an explanation about what APR is. So it's not that it's difficult for a father to get custody in Illinois. It's difficult for a non-residential parent and a non-primary parent to get residency and the primary decision-making in Illinois. And because statistically speaking, when there is a breakup and a breakdown in the family relationship, mothers are more likely to leave with their minor children, or mothers are more likely to stay with the minor children and to not be separated from them. It then gives the perception that fathers are on the outside looking in. It's undeniable that because of the way it starts, because of what the status quo is when custody cases are filed, since mothers have the children and fathers are not always with the children, it therefore lends itself to this perception that it's hard for fathers to get custody. What I'll say is Section 602.5 of the statute, and that is the IMDMA, the Family Law Statutes in Illinois. That section is called the Best Interest Statute. And the Best Interest Statute actually lists a number of different factors that have to be considered by the court before making a determination about what would be in any minor child's best interest. And what does that mean for you? That means that all of your evidence, all of your witnesses, all of the arguments made on your behalf by your attorney should be in line with the factors. It should be for the purpose of proving and establishing any number of these factors. Of course, the more factors that weigh in your favor, because that's what the court is doing, the more they're weighing your interest versus the interest of the other side. In this case, they're weighing your interest to be the custodial parent as a father versus the interest of the mother. And they want to know, when they weigh the factors and apply the facts of your case to the factors, what should be done in order to maintain the best interest of the minor child. So what can you do as a father to make sure that you are putting on the best possible custody case and positioning yourself in the best possible manner to be able to be successful in winning custody? 2 words: status quo. If you consult with any trusted and experienced family law attorney, they will tell you that judges love the status quo. And why is that? The status quo tells the court that before anybody filed anything in court, before any litigation was started, this is what the parties agreed was in the best interest of their minor child. And so therefore, it probably stands to reason that that is a good starting point for this particular family. So if the status quo for you is that you were the primary caregiver, you were the one who was picking up and dropping off for school, you were the one who was doing homework, you were the one who was the primary point of contact for teachers, for the principal, for the extracurricular activities, you were the one who was making the doctor's appointments and enrolling the children in this activity or the other, then if that's been the status quo, in addition to you being, in the household regularly or seeing the children on a very regular and very frequent basis, and if that's what the status quo was prior to the litigation, then the court is more likely to maintain the status quo. What is more difficult is going back to the initial point that I made, and that is not being the primary parent, not being the parent that the children who is currently, in possession of the minor children, being on the outside looking in and then asking a court to completely change the status quo. And that's because courts recognize that routine is generally healthy for children, that they thrive when they know what to expect, and they thrive in a healthy situation, and they thrive with a healthy routine. So if you can clearly demonstrate to the court during the course of this case that the routine has always included you, you have been an integral part of this routine for the minor children, then you're really, really going to be a long ways down the road towards having a successful custody case. Custody is difficult. It can be stressful. It can be long, and it can be expensive in many circumstances. And on the grand scheme of the level of difficulty of cases, I would definitely say that a father who is seeking custodial rights, meaning not just to make decisions, but to actually be the primary residential parent in Illinois, that sort of case is actually still on the more difficult end of the scale. So I encourage you to reach out to a trusted family law attorney to get their advice on the best strategy moving forward. But definitely just know that there is hope, and that as long as you have been integral to the upbringing of the minor children, these cases are winnable, and we win them every single day. I hope this has been helpful, and I look forward to seeing you on the next video.